impacting how we treat people. If you go back to the last slide, Rob, I'm sorry. There, nope, go back. There we go, okay. So implicit bias affects human behavior throughout society. So one of the things, my wife is a former educator, and her studies and things that she had to do in order to be an educator, you realize that in education, a lot of times we see at the end how implicit biases impact students, right? Not many times students of color are negatively impacted by harsher punishments in school for similar conduct, and many times they aren't referred to services for disabilities or screened for gifted programs because of implicit biases. And that's something that in education, educators are working through constantly. Those conversations are being held constantly. I've got multiple friends who are principals and educators are across the board in the education system, and they have these conversations on a regular basis. So it's actually important that as lawyers, we start to have that conversation about our own workplaces, about our practice, right? And ultimately, as a labor and employment attorney, I see how implicit bias works in the workplace on a regular basis. I see most of the cases that I deal with, I would say this, almost 99.9% of the cases that I deal with, they aren't really what I would say the overt, they don't deal with the overt racism or overt discrimination, whether it's gender, whether it's age. Usually it relates to stereotypes and what we'll talk about a little bit later, which is microaggressions. That's typically what we see in the workplace. Very rarely do I see the super overt, discrimination through, either through email or through language, but they do have an impact in the workplace. Go to the next slide. Okay, so examples of implicit biases. So I think probably the most easiest one to come up with, that's why it's the first one, is that, studies show that Caucasian people will frequently associate criminality with African Americans. That's one that I'm sure everybody's heard about in the news millions of times, but there's others, right? As we start to see, over the last, probably say 10 years in the labor and employment world, we're having to deal with, and employers are having to deal with the impact of, we now have 3 to 4 generations of employees in the workplace at the same time. And so with that being said, there are new challenges for employers that they have to deal with. They have Gen Z people, entering the workplace now, and they still currently have baby boomers in the workplace. And then they have everything in the middle, right? Millennial, I'm a millennial, and then they've got Generation X as well. And many of those people are leaders in the organizations. And they have to deal with the fact that some of these generational gaps, there are actual true and real differences between the workforce based on age. And so what we're starting to see is a lot of older workers being, what I would say, there being a lot of implicit bias related to older workers and their ability to learn new processes in the workplace. I know it's funny now, but the memes and the Facebook and the social media okay boomer terminology is something that you're really actually starting to see in the workplace. And so, and that's the same thing in the legal profession. The legal profession is starting to see this as well. I see it in my office. We have, I believe, we have the 4 generations of workers in our office, and we're having to adapt to that. We're having to adapt to how people work, how they interpret information, and so those are challenges that we all have to deal with. One that I've seen multiple times related to females in the workplace, a bias that people have is that it's their job to take care of the family, and so their families come above their job duties, and that's something that is unfortunate, but that's an implicit bias that's out there. One of the things when I first got into the legal practice, one of the things that was like the silent whisper, which was that minority lawyers needed more training. You had to train more and harder to train a minority lawyer or a lawyer from, either be female or African American or, you know, a person of color, that you had to give them more training in some way. That's something that I heard a lot, not in my firm, but specifically when I talked to my cohorts at other firms. That was something that was out there. It was kind of like this silent underbelly that of firms and organizations that they had to train more. So that's something that in the legal profession we've had to deal with, and we'll probably continue to have to deal with. You can go to the next one. I also like to say, before I move on to this next slide, not all implicit biases are negative, right? I think there's one that I missed on there, but it's one that, as a kid who went to, I don't know if any folks who who are from St. Louis, you know, the high schools. I went to Parkway Central, and one of the things in Parkway Central was, and it was kind of a known thing, which was this stereotype that your Asian American students were your best students. They all were in the orchestra or choir, and they were the best students. They worked the hardest, and they were going to be your shining light students, right? And that was kind of the stereotype in my high school at the time. And that's not a negative stereotype, right? That's not something that most people would say, well, that's not a bad thing, right? However, I tell this story because it makes you start to think, right? While it's not a negative stereotype per se, imagine if you're that Asian American student who isn't the greatest at school or isn't in the orchestra, and people have that expectation of you. I recall specifically in high school, my brother is a chemist by trade, and I'm 4 years younger than he is. And we ended up having the same chemistry teacher. And this chemistry teacher had this idea that I was going to be just like my brother, who was 4 years older than me, and this great student, this great chemistry student. And I was horrible at chemistry. I mean, that's why I'm a lawyer now. I did not like science. I was okay at it, but it wasn't my passion. And I remember that professor basically throwing his expectations on me because of who my brother was. And so imagine having that same type of expectation just because of the way you look, or because of your culture. That can be damaging. While the stereotype itself is not negative, the impact and how you treat that person and the expectations that you might throw on that person might have a negative impact on that individual. So defining microaggressions. So microaggressions is kind of, I'm jumping ahead here a little bit, but basically the best way to look at or think about microaggressions and implicit biases together is microaggressions are the manifestation of your implicit bias. So your implicit bias is this thing in the back of your head that you sometimes don't even realize is there, but you've received that information and that thought process through socialization and through your events that it might have occurred in your life. Microaggressions are how you end up treating people as a result of those implicit biases, right? So Dr. Wing Su, a professor of counseling, he basically says that it's a series of snubs and slights that people receive as a result of, and it's basically a day-to-day interaction that people receive as a result of of other people's implicit biases. So, they're everyday verbal and non-verbal slights and snubs that people feel, they cause people to have hurt feelings. And a lot of times the person who's doing it doesn't realize they don't realize they're doing it. And they sometimes think they're complimenting the victim of the microaggression. And we'll see some examples of that in the next couple of slides. You can go to the next slide, Rob. Thank you. So microaggressions are often discussed in racial context, but they also can deal with any other group, what we in the legal profession in labor and employment, we call the protected activity or the protected groups, right? So you have your gender, sexual orientation, disability, religion, age, of course, should be up there as well. I've had cases where individuals who were older felt like, I have a manager, a supervisor, or whoever who sends me emails constantly that seem to be providing, they're just giving me digs about my age. Every time they have a critique of me, it seems it's about my age, right? I've seen that. Same thing for religion, disability, and sexual orientation as well. Microaggressions, they usually are the everyday. They're so not really those extreme events. They're a lot of times what most people would think would be innocuous comments, but when you add them on top of each other, it starts to make the recipient of those statements feel as if you're picking on them, or that you're making these comments because of some protected characteristic, or because they're in a marginalized group. Unlike other forms of discrimination, the perpetrator a lot of times doesn't realize they're doing it, right? They don't realize in an email they sent that they thought was perfectly fine about this person's work, or they thought they were being nice and complimenting them. They don't realize that there's an actual slight and a dig in their email. And microaggressions can be overt as overt, as watching a person of color in the store. Of course, we've seen that example many times, but that's not typically what I see, and I don't often see that in the legal profession either. And not specifically, not between lawyer to lawyer, and not between lawyer and their staff, or lawyer and a judge or their client. Usually, it's more what I would call the subtle digs. Let's go to the next one. So there are 3 categories of microaggressions, and I didn't create these definitions. These are definitions that have been created by people who are a lot smarter than me. But I want to provide these to you all so that you kind of have a understanding of where the kind of the range of what microaggressions can look like. So of course there's micro assaults, and those are the most overt comments, right? It's basically like a derogatory term for a person of color, or for a person who's in a protected group, calling straight up calling somebody old, or things like that. Those are the micro assaults, the super overt. We all know what it is when we see it. Those are the easy ones. We rarely see those anymore. And at least in my practice, I don't see that quite often. Micro insults are more subtle than micro assaults, but they're still very harmful. For example, a micro insult could involve a comment implying a woman or a person of color received their job because of affirmative action, or that they're the token, right? That while that's not super duper overt, it is still an insult that that person didn't receive their position because of their merit, but just merely because of their membership in a marginalized group, right? So that's one of the things that we see that sometimes. That's not, I don't see it as often. I think when I first started practicing that we saw that, but I don't see that as often as I see the third category, which is micro invalidations, right? Micro invalidations are you're saying to an individual that how they feel about a specific situation is invalid, or that their concerns are invalid. So for example, one that sometimes you can see, you hear all the time, is that people of color, or people of different sexual orientations, are overly sensitive about discussing race or sexual orientation, right? So those are the micro invalidations. Those things can make an individual feel as if you're not listening to them, that you don't quite care about their perspective. And those are the type of microaggressions that really, the slight digs that can really make an individual, not enjoy their either employment, interaction with you in general. And I've seen, this is about I'm providing this guidance because we've seen this not just in the workplace. I mean, unfortunately, I've seen lawyers do this even to their own clients and to their own judges. Who you're with a judge, you're trying to convince them that your case is, that you're right, that your position is correct. And I've unfortunately seen lawyers in my 10 years of practice use micro invalidations with the judge, where of course, that I'm not saying the judge would rule one way or the other because of that, but I'm sure the judge probably had to think twice when somebody is throwing those type of things at them, and who's trying to advocate for their client. I've also seen this, unfortunately, with people with lawyers and dealing with their clients. Let's go to the next slide. All right, so some examples, generic examples of microaggressions, so you kind of see what we're talking about. Sometimes it's easier to explain it through examples. I won't go through all of these, but some of these are ones that, you know, unfortunately I've heard. For example, asking a biracial person, what are you? Unfortunately, so my kids are biracial, and I've actually had, and they're younger, but I still have heard people ask them what they are, right? That might be something that makes, you know, would make a person of biracial descent feel a type of way. What do you guys speak in Japan? Asian, right? Well, you know, that sounds silly and stupid, but unfortunately, in my practice, I've seen people make those type of comments to an employee or to somebody in the workplace, and it's unfortunate. One that I usually have to explain to people, I didn't realize that folks didn't quite know what this meant, but you're long in the tooth. So that's usually a euphemism about somebody being older. I actually had a case related to that term being used about an employee. So these are things that can, of course, while they may not be super overt, they are microaggressions, and they can make individuals feel unwelcome in the workplace or in any you know, in any place when those things come up. This is actually another kind of real life example of a case that I've dealt with. You don't know how to use the computer, you're old school, right? So this person is being told that they're old school because they don't use technology the way that this younger individual uses technology. Again, it's an invalidation of that person. It's a micro insult, right? So these are the things that we're talking about when we're talking about microaggressions. You can go to the next one. All right, so we talked about this already. So bottom line, microaggressions are the manifestations of an individual's implicit biases. And everyone has them. As we said, we all have implicit biases. Our goal with this training and our goal with whenever we talk about microaggressions and implicit biases in the workplace or in legal profession or in just in life in general, is that we have to, the first step is identifying what those implicit biases are that you might have. And I didn't include this in my training, but there are actually really helpful organizations that have websites, have tests that they actually will help you. If you can't do it yourself, they will help you determine where your blind spots are. Because that's what I call, implicit biases are really your blind spots, right? At least that's how I put them. And you want to be able to identify where your blind spots are so that when those things come up, you're able to, you know, understand that and then say, let me think twice. Let me think harder about this email or this communication so that I don't end up having some type of microaggression in that communication, whether that's to a coworker, a staff member, another lawyer, or a judge, or your own client. So that's really important because, as I said, I've unfortunately seen lawyers include microaggressions in their, you know, in their communications to the coworkers, their staff, opposing counsel, judges, and their own clients. So we can move on to the next one. All right, so quick studies just to show what we're talking about, how it can impact, how microaggressions can impact people. So in 2017, the Center of Health Journalism explained that racism and microaggressions lead to worse health. A lot of times what ends up happening is because it's an everyday thing, even sometimes because it becomes an everyday thing with the snubs and slights, even things that may not be a microaggression might trigger that person's symptoms. They might think that you're being microaggressive towards them, even when you're really not trying to, or even when you're not, because of prior microaggressions that they've received from you. In 2014, a study of 405 young adults of color even found experiencing microaggressions can lead to suicidal thoughts. So, you know, these things have, you know, microaggressions have a real impact on people. I've talked to a therapist before about how, you know, for a lot of her patients, whether it's people of color, whether it's female, and even some older, her older clients, she basically told me that, yeah, microaggressions are one of the major reasons some of my clients are my clients. That they feel they're dealing with this barrage of insults on a regular basis from different people from different areas in their life, whether it's work, whether it's at home, whether it's, you know, with friends. And it's really hard for those people to deal with those issues, specifically when it's hitting them from all areas. Move to the next one.
Dean, I just want to mention we had a question from the audience, and folks, if you have questions, there is a chat button that you can hover over the bottom of your screen. The questions will be addressed to me, and I'll pass them on to Dean. One that came through is, in a law firm, how can a woman with a family address the stereotype that she prioritizes her family over her career?
That's a really good question. Thank you for asking that question. I think that one of the things that we'll talk about a little bit later, but I want to address it now, is it's about having the ability to, first of all, it's about culture, right? Everyone's firm and everyone's organization is a little bit different, but what you want, if you want to have a successful firm or organization of lawyers, it's about having the ability to have hard and sometimes difficult conversations with your coworkers and your staff, so that these type of issues don't come about, or if they do come about, being able to resolve them in a professional manner, right? So one of the first things I would say is that if that's for a female, I'm not a female, so I can't really speak to that perspective, but I can speak to the perspective of being a Black man, a minority, in a law firm setting. And one of the things that my firm has been really good at is that we're very open with each other. We're able to have conversations and sit down with individuals and have conversations, so that if I feel as if, you know, someone said something that might trigger that, hey, what did you mean by that? I have the ability, and I feel empowered to have that conversation, and we can have that conversation without really, you know, resolving it there. For a female attorney, you know, one of the things that I understand that perspective. I've got 2 younger children, 1, 2, and the other 6, and it is very difficult for women in the workplace, in any workplace, but specifically in the legal field, to juggle both. We all have issues juggling both. I mean, specifically right now that we're all sitting at home with our children are out of school, and we're still trying to practice law, right? But one of the things is being open, right? Having them understand, while my priority is always going to be my family, I'm still willing to do the things necessary to get the job done, and showing that dedication in other ways. That doesn't always have to be staying until 10 o'clock at night, right? I learned that as a young lawyer as well. Like, you don't always, I mean, yes, you want to get the work done, and you want to show your firm that you're dedicated to the firm, its mission, and its clients. But, you know, we also have lives, and we also have children to take care of. And we also have husbands and wives that we have to support through emotionally, not just economically. So having that conversation from the get-go, from the beginning, is extraordinarily important, okay? Because what that does is it sets the tone for them to understand, the firm to understand where your priorities lie. That, yes, I'm dedicated to the firm, but I still have a family. And then sometimes, and this might sound bad, not bad, the reality sometimes is some cultures don't always fit you. Some cultures are not going to fit you, and you have to find the culture that fits your abilities and your work and your life and your workspace. What I would say though is that if you want to have if your firm wants to have an inclusive workspace, that they will make adjustments so that all lawyers, regardless whether female or male, but specifically female, feel comfortable being able to practice the law the way the law requires, while also spending time with their family, taking care of their children, having flexible schedules, right? I think my firm's been really great about that, which is, hey, honestly, as long as the work's done, you could do it at 10 o'clock at night at home, or you can do it, 5 o'clock in the morning. If you got to, take a kid to a doctor's appointment, dentist appointment, that's for you to handle. We're not here to police you on that. We want you to take care of your families. We want you to be able to spend time with your families. So our culture is really, really good about that. So one of the things I would say ultimately, and that's a long answer, I'm sorry, but it's about culture, and then it's about having a truthful conversation, and sometimes might be a difficult conversation, but a truthful conversation from the beginning about everyone's expectations, and finding out where those expectations lie. And that conversation might even have to happen before you even take that job. I don't know if that answered her question, but if you want to have a longer conversation about that and provide some feedback, feel free to give me a call. I think my information is in the presentation, and I welcome people giving me a call or emailing me and set up a call just so we can have these conversations, because I think they're important. Moving to the next slide though, it's not uncommon. Oh, no, go back to, sorry. I didn't really talk about that. Thank you. There we go. So many times lawyers unfortunately bring their biases and stereotypes to their practice in a firm. And so let's talk about this. These examples are specific to the legal profession, okay? In an email to a female paralegal, a lawyer states, "I know you're busy at home with your kids and husband, but I need you to be more dedicated to your firm," right? Or to your work. Let's just assume, and we'll talk about this a little later, but let's just assume that this employee does have a dedication issue, right? Maybe they're not getting the work done. This paralegal isn't getting the work done, okay? There is a way to present that concern without including this microaggression about her family or the familial status that this person has, right? It's about facts. How did they show you that they aren't dedicated to their work? Or is this just an implicit bias that you just have an issue with? If there is actual concern, what I always tell people, and I tell my clients this, you want to talk about the facts. What did this person not do? When did they not do it? How did they not do it? And how did they fix it? Because this communication to me means nothing, and all it really does is demonstrate that you have a microaggression, or that you might have an implicit bias against women in the workplace. And so it's about providing facts about what are the concerns, if there is actually a concern, right? When meeting with a young African-American coworker, the older lawyer states, "Young lawyers these days don't care about the practice of law like we used to. You all just don't fit the firm culture." Okay, so that is one of those things that I think my firm hasn't really had to deal with this issue, but I've heard of other firms. I've had younger attorneys that I mentor and that I'm friends with have heard these type of comments before, that the idea that working from home, or the idea that remote working, or the idea that of a work-life balance, right? This idea of work-life balance is this poo-pooed issue that only young lawyers want to do, and we don't care about the practice. That's a microaggression, right? Whether, I know that being young isn't specifically a protected category under the law, but the idea is that this still is a microaggression, because it's towards these younger people, these younger lawyers, the future of your firm or future of your organization. And you're making them feel uncomfortable because you're telling them they don't fit the culture, because they want to have work-life balance, because they want to work their butt off maybe between 7:30 and 6, and then they want to go home for dinner and maybe have weekends for themselves. And I know some firms' culture doesn't fit that model. But those are the things that unfortunately can drive lawyers out of your office. You can lose your diversity and inclusion. This is what I had a conversation with a friend of mine a few years back, who was a staff member at WashU, or not WashU, SLU Law School, and her entire job was to help law firms in St. Louis, get promising law students in their firms, and in that process was, we're trying to really meet our diversity, our inclusion mission. Okay. And one of the things that she said to me when it really hit home for me was, she goes, some firms have a great strategy of recruiting these diverse candidates, getting them in the door, but they have a terrible strategy of keeping them in the door, and so that they're the future of their firm, right? And to me, those type of examples, or some of these examples that I'm providing, are part of that terrible strategy of keeping good workers and good lawyers in your practice. Because, I think no one starts a firm, I don't think, to not be around 20, 30 years later. They want that name, that firm, or that organization, whether they work for a corporation or a nonprofit, they want good people to continue to work there 20 years, 30 years from now, after they're long gone. But unfortunately, a lot of firms and a lot of organizations are good at getting people in the door, but maybe not as good as keeping them in the door once they're there, because of things like that, right? One of the things I always tell people is related to the 4 generations of workers in the workplace, is that while each may be a little different, we all share some commonality, and that the struggle, and that the hard part is finding that commonality and then trying to work through that, right? But it's our duty as lawyers to try to find those commonality within our organizations and within our whether it's a in-house counsel department or whether it's a firm, to find the commonality and then meet people where they can do the best work for you, right? This is one that I've seen some lawyers do before, send a communication to a client that I thought was a little presumptuous, maybe included some stereotypes about that client or prospective client. And that's one thing that can impact your actual practice. It can impact your bottom line. If you don't quite understand how to communicate with individuals, and you include implicit biases to prospective clients or to your clients, you could run into a situation where even you're missing out on business that you would have otherwise, because you included some maybe a stereotype or something slipped out, or microaggression slipped out in your email that made that client say, you know what, maybe I don't want to hire this guy, I'll go to the next one, or this lady, I'll go to the next one, right? I'll find one that doesn't make me feel attacked in some way through email communications. You can go to the next one. All right. So implicit bias, and I kind of talked about this already, how it impacts your business and how it impacts workers in the workplace. I won't read you the statistics, you can see that, but ultimately the bottom line is this. It is like one of the number one causes for turnover. People who feel like they're having might have to experience daily microaggressions and daily snubs and slights. They are not as good as workers. They have anxiety, they have anger, and they are basically the ones who will lead. We all know that turnover is extremely expensive. For in the legal field, I don't know the exact number. It used to. I used to a few years ago, but there are numbers to how long it takes to train a lawyer so that lawyer can be the most profitable they can be for your organization or for your law firm. And if you unfortunately are undermining your own training by these everyday digs and slights that they feel, and they go somewhere else and they take that training. So you spent a lot of money training that individual, and then they take that training and goes to another firm or to another organization. You've just lost a lot of money, right? You've lost a lot of the money that you've invested in that person to being the future of your organization. So there is a dollar amount that results to having these issues in your organization. And it's not just, lawsuits. It's also losing good people to other organizations because of these type of microaggressions. You can go to the next one. All right, and to specifically this point, it is the number. Like, so I say this constantly, and I've said this before in other trainings before. Again, 99.9% of the cases that I see that come across my desk don't include overt, acts of discrimination. They typically include the everyday microaggressions, snubs that people feel as if they don't want to work there anymore. They are the reasons why we see hostile work environment claims, discrimination claims. And unfortunately, if they're unchecked, if HR professionals don't check supervisors and managers' evaluations, their discipline that they issue, communications that are issued to workers, and if leaders in organizations, including firms, aren't paying attention to how they communicate with their staff and other lawyers, it can lead to these type of these legal issues and these lawsuits. And it's the number one reason why be real. This is the reason why I've got a job, is because unfortunately, some people cannot weed these things out of their communications with their staff members and with their coworkers at work. So, I tell people all the time, typically when people do discrimination training at work or in their firm or in their organization, they usually talk about the most overt types of harassment and discrimination, but they really should be talking about our implicit biases of microaggressions, because those are the things that will lead to lawsuits probably more often than anything else. You can go to the next one. All right, so I think we talked about with the one question, a little bit of how you can address microaggressions if you feel like they're happening. Dr. Sue actually provides a very good kind of tutorial on how to address microaggressions in real time, and having those typical conversations, because sometimes these conversations are difficult. One, because you don't want the person who might be the person who said the microaggression, you don't want them to feel attacked. You don't want them to feel get defensive. You just want to explain to them how you felt as a result of their comment, and maybe give them the opportunity to explain themselves. There might be further explanation that they can give you that disarms the entire situation, right? And so Dr. Sue calls it, he terms it micro interventions. And they're, you can ask for clarification. Could you say more about what you mean by that? How have you come to that, right? There are a lot of times where people say certain things, and I talked about it earlier. They don't include, they make these stereotypical conclusions, or make that what might sound like a stereotypical conclusion, but they don't include the facts about why they came to that conclusion, or they don't provide context, right? And so sometimes asking for more clarification about why someone said something can provide them the opportunity to explain, give context, and then maybe that will solve the microaggression, or make you even realize it wasn't a microaggression, or wasn't intended to be a microaggression at all. Instead, there actually is a legitimate reason for what they said, and you guys can actually have a conversation about it. You have to sometimes separate the intent from the impact, right? You say, I know you didn't realize this, but when you said X, it was hurtful and offensive because of X, right? A lot of times people say things, they mean to say something, they mean to communicate it in one way, but it just comes out wrong. And it might come out wrong because they have a blinder, they might have an implicit bias, but it's just sometimes they just flub up and it just comes out wrong. Instead of jumping down their throat, right? Try to see if they meant something else compared to what they actually said, right? Try to separate the intent from the impact so that they feel comfortable, and maybe they can provide an explanation, and then again, give context, and then maybe even change how they word the thing that they said to you, or share your own process. I noticed that you did this or said X. I used to do that too, but I learned X, right? That is a really easy way. It's empathizing, and I know sometimes it's hard when you feel like you've been attacked, but I think a lot of times, it's not intentional. You want to empathize a little bit with the individual who made the comment, or you want to diffuse the situation so you can have that difficult conversation. And again, as I said, we all have implicit biases. We all have probably been microaggressive towards someone at some point in our lives. I know I have. And this training actually that I give has made me even think about my own communications, not only to associates in my firm and other partners in my firm, but also my communications verbally to clients, to judges, and also even in my personal life with my wife and with my friends, right? Sometimes you can say, it's easy to say, you know what, you said this, and I used to think that way too, but let me explain why I don't think like that way anymore, why that becomes an issue. Attempt helping the aggressor understand, that they aren't under attack, that you're not attacking them, but that you want to have a conversation about the things that they've said. So that those three are again, I didn't make these up. These came from Dr. Sue, and I think that they're. I've tried to use them in my own practice and in my own experiences at work, and they've been actually really helpful for me. You can go to the next one.
Dean, there were two questions on this topic, and they're from opposite sides of the conversation. One, what happens when these microaggressions happen in a meeting? So you're in a conference room with 6 others, and one or more of them, let's assume that there's one person in that room, expresses something that's inappropriate.
Okay.
Is it something that you feel is best to address privately with that particular person after the meeting? Or is there something that would cause you to respond immediately? The flip side is, if you're the person who made the statement and it was either brought to your attention or you recognized later that it could have been interpreted in a way that was insensitive, how do you deal with that? Do you go to that person and apologize? So on both sides of that issue, what would you suggest?
Those are great questions. I'm glad folks are really thinking about this. I appreciate that, because on the first one, I would definitely, it depends. I would say it depends on the severity of the comment, right? I think there are some comments that are so inappropriate, like if it's a micro assault, right? That it's so appropriate that you feel like I've got to nip this in the bud right now. And then maybe I can have a later conversation, say, hey, stop right there. I don't quite appreciate that comment, a little inappropriate. But we'll have a further discussion later. I have no problem with that. I think that's 100% appropriate if it is of that severity, right? But then there's other times where it is more micro insult, maybe, and it's a invalidation, where I think it's 100% appropriate to have a conversation after the fact, allow the meeting to end, maybe jot down what was said so you remember specifically what was said, go to that individual, set up a meeting, if it's, whether it's your boss or whether it's another associate or partner in your firm, set up a time to talk to them, come to your office and have that conversation, because I think it's necessary. But I would do it sooner than later. I wouldn't wait, weeks or days to do it. because you want them to remember what was said. You want them to remember the context, right? So you can have an honest conversation. But I would definitely have that conversation later if it's not of the overt type of microaggression. Like if it's more of an insult or more of an invalidation, you felt invalidated in some way, then maybe I would, wait till the meeting's over, have that talk, have that discussion. And then this is the deal. And for example, if you felt that way, there's a very good chance that other people in that room felt that way, right? And maybe after that conversation, that private conversation one-on-one, maybe have a discussion with the group and say, hey, this was what was said. We're not, we've pieced it up. There's no issues, but we want to make sure everybody understood that, this is the context. This is was meant. We didn't mean it this way. I have no problem with that. To the second question related to the person who actually made the comment. It's actually very funny. I did a similar training about 6 or 7 months ago when we were doing this training, and I actually had a attendee in the middle of my training stop and say, I think I just sent an email to this morning that was a microaggression. She said that, and it was funny because she stopped our meeting to tell us that. And we're like, okay, and she said, I'm going to apologize, and I'm going to clarify what I meant. So I think that it's 100% okay if you feel like you've identified it without the person having to come to you, and you want to just clarify to make sure that they didn't feel that way. There is nothing wrong with that. And in fact, that is great. I think that's 100% appropriate to say, that didn't come out the way I wanted it to come out. Let me go talk to this person and make sure they understand that that's not, if there's any confusion, that is not what I meant. This is what I really meant, and let's have a conversation. If somebody comes to you and says, hey, what I would say is sit down, have this conversation, and really try to be empathetic about why they might feel that way, and really think about how you might have been able to word that communication differently so that they won't feel that way. Again, I think if you stick to facts and stick to objective criteria when you're discussing certain matters with people, a lot of times you don't have to worry about that. But I think that in both situations, it's about thinking and doing a little self-reflecting. I've had to do that myself. Several times I've had to go back to my own emails and talk about that. I hope that answers both of those questions. You can go to the next one, Rob. Thank you. All right, so this kind of talks about what we talked about. I know we're running a little bit behind. Lawyers, and whether it's in a firm setting, whether it's in an organization, whether you're working for the state, whether you're working for in-house counsel or organization, it doesn't matter. Receiving training on implicit bias and microaggressions, it's extraordinarily important for the legal profession because it really does impact I think it impacts your bottom line, number one, because I think, as I said before, a lot of firms do a lot, and a lot of organizations do a lot of good at meeting their mission of diversity and inclusion, but it cannot stop once those individuals enter your workforce. It cannot stop once they're a lawyer there. You need to be understand that there are certain things that happen during their employment that you might need to address. And so provide training to these employees, to all your employees, your staff, so they understand what microaggressions look like, what implicit biases are, so it diffuses the conversation. A lot of times the conversation never happens because we're all afraid of having the conversation. So when you train individuals and you have the discussion, then they're probably more likely to have open discussion about how they feel about these things in real time. One of the funny things that I'll tell you about, if we're not running too much behind, is I've done a similar training with a municipality here in St. Louis, the St. Louis region, and it was a more rural community. And one of the things in one of the trainings, in that training, one of the things I usually do is we do this game where we talk about what the implicit bias might be about me or about each attendee. And one of the things that really enlightened me was, and this wasn't a very, it wasn't a very diverse group of employees, right? It was actually mostly male, mostly white, but they did a really good job of having this conversation. One of the gentlemen, you write on a tab what stereotype people might think about you. And one of the things that he wrote was, because I'm from this community, everyone thinks that I'm, you know, a gun-toting, hunting, you know, conservative. And, you know, I said, okay, I get that. I understand. This is the community that you're from. That is the stereotype in this community. And he was like, you know, but that's not true. I hate guns. You know, and he went down a list, and you know, it shocked me that he, and a lot of the people, his coworkers kind of were in, you know, they didn't really even know that. And so it really opened up the conversation for that organization to have meaningful conversation. And so that's one of the things that really can happen in these type of trainings. When talking with staff, like I said, use objective criteria, use careful wording in your communications. Listen, I'm not saying it should take you 15, 20 minutes to write a two-line email, but when you're having to have conversations that might even be a little unpleasant, make sure that you use you word things carefully so that you weed out any of the potential biases or potential aggressions that it might be in there. Lawyers should stay away from terms such as cultural fit and overly sensitive, or be more approachable. There are ways to define these things objectively so that somebody understands that they might actually have some deficiencies in their performance or their activities in your organization, and just try not to make assumptions and acknowledge that, you know, acknowledge what makes people different without treating them different. I think that is the biggest takeaway a lot of times in these things. And when we're talking about diversity and inclusion, I think I've got like 2 minutes, or maybe I'm almost done. If you go to the next slide, one of the things that I like to talk on these conversations is that diversity and inclusion is extraordinarily important in the legal profession, because we know for a fact that diverse groups of individuals can solve problems. They can solve problems quicker. They can find problems quicker. And as lawyers, that's extraordinarily important. Everyone's different perspective, whether it's culturally, generational. When you combine that gumbo of experiences, many times those groups that are more diverse can solve problems for their clients quicker, more effectively, and you're just all around a better organization, right? And so what we want you all to do is to make sure, because we know that, let's make sure the everyday interactions with each other meet our objective in making sure that our organizations remain diverse and inclusive, right? So that's the goal. That is our mission in a lot of our organizations. I know I'm almost running out of time there, Robert. If you go to the next one, I think I've already kind of covered that one.
Okay.
I think, there we go. So we're kind of on this slide here. So I don't know if there's any questions about any additional questions that are out there. Personally, I've witnessed the power of diversity again, that can assist lawyers in their day-to-day litigation practices. Quick story, is funny. One of my partners is in his early 50s. He's one of the guys that I worked with probably the most when I first became a lawyer. And he told this story about how he was taking a deposition, and it was a younger Black male that was the witness. It was a witness deposition, and they were describing a scene, and he was saying that it was him and his girlfriend and this other guy, and he continued to talk. And then as he starts to continue to explain the scene, the term girlfriend changed to a slang term for girlfriend, which is shorty. And he started saying my shorty or shorty. And my partner goes nuts, because he's like, wait, you said there were 3 people. Now there's 4. What's happening? And it's so funny, because as he's telling me this story, I stopped and I said, there wasn't a 4th person. And he goes, what do you mean? I said, there wasn't a 4th person. He goes, how do you know that? I said, because shorty is a slang hip hop term for girlfriend. And he goes, man, I'm glad you're around. And so it's just a silly example, though, of how we all bring different experiences and different cultures. And even in that, right, it might seem silly, but in that situation, he actually thought there was a fourth person in this scenario. And it took me, a younger Black man who grew up in the hip hop culture, to tell him that, hey, that's a hip hop term for girlfriend. He just changed the terms. There isn't a fourth person. And so that's just a silly example of how diversity can really help us in our legal practice. Those type of things really come up all the time. Me and him have had these conversations a million times. And I promise you, vice versa. We've been in that situation where he has to lean over and explain something to me, and I'm like, oh, okay, yeah, there we go, got it. So if there's any, I know that's I'm running over time, but if there's any questions, I'll take them. If not, I'll always be willing to take questions via phone or email.
Dean, thank you. That was an outstanding program, ladies and gentlemen. It is just wonderful that we have folks who are giving of their time and including young lawyers who are devoted to the profession and to those in our community. And Dean, thank you. That was really thought-provoking.
Thank you.
So, folks, just a couple of administrative matters. Kelly Spiller of my office has shared a couple things. And first, I want to thank Kelly, who has been the person who you've all been communicating with and receiving the link to this program. And Kelly's been doing this for north of 10 years, and she has been terrific. I also want to thank Dan Geigerman, who is our technical specialist, since some of us are not are technically challenged. So we appreciate his assistance. Those who are attending just by telephone, if you would email Kelly to identify yourself and that you attended, and also to everyone to remember, if you would submit your evaluations, there is an eval form that is included with the link. It's towards the front of the package. That will help us. And the one thing I would ask of you is to tell us, are there particular areas of practice that are of interest to you that we could consider for future programs, and who you might suggest would be an appropriate speaker in those areas. So that's super helpful. Also wanted to let you know that while Dean was speaking, we actually heard back from the folks in Illinois that approved the credit for our Illinois program, including the professionalism credits for Dean and for Stephanie, who will be speaking in our third segment today. Kelly, I think I've identified that. Also, those who are seeking Illinois credit, if you're communicating with Kelly or you're sending in your eval, just make sure you have your ARDC number so that we can provide that when we submit all the information for Illinois credit for you. Most importantly, I'm thanking our speakers. Everyone is terrific. Let me close out of this particular let's see, I'm going to stop sharing for just a minute. And we're going to change up our materials. So the next program is a discussion that many of us are involved with at this point, and that is most are working from home. Those of you who are sitting in your feety pajamas, we're not going to identify you. But how do we mediate, and how do we arbitrate, and how have we done this from a distance? And we have looked at this particular matter and worked on it over the past several weeks. In your material is a 4-page outline and then a PowerPoint that we're going to cover. So as part of this program, my colleagues, Mike Geigerman and Kirn, are joining me to talk about this particular topic. Both are mediators on our panel. Kim also arbitrates for AAA and FINRA and arbitrates and mediates for our office. I thought we'd spend just a minute or two to talk about where have we come from and where are we right now, and maybe a little bit of a prediction of where we're going. Kim and I are going to split up this first segment, and then Mike is going to take the second half of this hour. Obviously, in the past, we have mediated and arbitrated in person, primarily. But that's not to say that's been the exclusive manner that we have conducted mediations. I have done arbitrations in the past by telephone. I have mediated where I have one party with me and we're contacting the other party out of town by telephone. We have a joint session, and then I'm back and forth from one person in a room to another office where I'm calling the other side, and we go back and forth. So that's something that has happened in the past and continuing today, and I think will happen in the future. Those kinds of cases are not the most complex. Granted, I've been doing those kinds of telephone or joint telephone and in-person for a big box chain, and they're premises liability cases. So not always that complicated. But I think that we know from our past that there has been a trend of parties less willing to travel, companies less willing to pay for folks to travel, and I think that will continue after we get past where we are with COVID-19. The future is, I think, going to put us in a situation where we will have mediations in person, arbitrations in person, but remote mediating and remote arbitrating, in my opinion, is here to stay. And I think when we talk about some of the pros and cons in just a minute, you'll have a better handle on why that's my opinion. Kim, you were going to talk a little bit about the notion of confidentiality and privacy as well.
Yes, thank you, Rob. Hi, everyone. My name is Kim Kirn, and I have been doing a lot of virtual mediation and virtual arbitration. And maybe I'm the beneficiary of a microaggression. I'm maybe younger than some of the other mediators, so people assume I actually do know how to use a computer. I don't know. I told Rob I have a joke before I start that I want to share with all of you. I want to encourage you to socially distance from your refrigerator to help flatten your curves. Okay, on that note, confidentiality and privacy when you're doing a virtual mediation, make sure that you're very clear with everyone participating that they identify who's in the room, because of course, you know, you guys don't know who's in the room with me right now. And if we're in the middle of a mediation, it's very important that all the parties know exactly who's participating. You know, the people who are in the room technically need to sign the agreement to mediate. There's important information in that agreement to mediate on confidentiality, on not who can be, you know, later called to testify. So make sure that if there is somebody else participating, and this would particularly be maybe a spouse or an adult child, you know, they need to sign that agreement to mediate. So it's important, I think, up front to know who's going to be participating. I've done a lot of work via Zoom, and what I've been doing is sending out the agreement to mediate in advance and asking in my email messages who will be participating and try to make sure that we're very clear on that. I also want to talk about recording of the sessions. And if you look in your upper left-hand corner right now, you should see, I see a little box that says recording. Do you see that? Yeah. So you know right now that USA&M is recording this webinar. And again, I address this in my virtual mediations to tell everyone that they are not allowed to record and that I will not be recording. And you can be assured of that in two different ways. First of all, if someone tries to record, it will pop up and it will show you that they are recording. So if you ever see that, you know, jump up and down and stop immediately. But I actually have, and anyone who has a Zoom Pro account, they have the ability to disarm or to disable the recording function. So I have done that as well. So if you're doing a mediation with me on Zoom, you won't have the opportunity to record because I've disarmed it. Okay, back to you, Rob.
Great. Thank you, Kim. You know, one of the things I think that is generally important to consider as we're talking about this remote mediation or remote arbitration is it is parallel to what we do in person. Just like, you know, people in a conference room should not have their phone recording what's going on. Just like in person, someone who is in attendance doesn't have their phone and they're sitting there doing the play-by-play of what the offers and demands are on Facebook, right? Confidentiality is confidentiality, and it's incumbent on all of us to work with our clients. So what are some of the pros and cons of remote mediation? Folks, we're in a situation where none of us on this call know what's going to happen in the future. But I think many have opined that when the world opens up, the notion that there are going to be civil jury trials immediately may not happen. I spoke to a lawyer last night on a matter, and he has a case in California, and the lawyers there are suggesting that there's not going to be a civil jury trial in California in state court until next year. That criminal cases will take priority, and it's going to take some time. So one of the effects of our current situation is there is an incentive certainly on plaintiffs because of this time component to settle. And there is also an incentive on the defense bar to continue to close clients and impress upon their clients that they're there to do the work and to work a file and move it along and get it closed. You know, at the end of the day, every case is like a stool with 3 legs, and there's risk and there's time, right? And then there's expense. And I believe through the process of doing this remotely, you can save on expense. People are not traveling. You can save on time because you can set up calls quickly and easily. And then the risk component is something that we're going to talk about in the mediation. But I think both sides of the equation, the plaintiff and defense sides, can look at this and see benefits. In terms of issues with your clients, when clients and lawyers are not together, there still needs to be a line of communication. Kim, I thought you were going to chat a little bit about an occasion you had where you had both the lawyer and the client together, and then the rest of the the group participating was by Zoom. Is that right?
Yes. And I think what you really have to think about in doing a Zoom mediation is to be very flexible and fluid. And at this point now, I think I've done more than a dozen, and I've had every variation. I've had a lawyer and a client together in a conference room. I mean, socially distancing, but they were physically together. And we had then the other parties all participating virtually in different places. And what is so cool about Zoom is it has a breakout room feature. And I know that Mike is going to talk about this later, but I've been using it like crazy. I mean, and setting up all kinds of breakout rooms, including, you know, breakout rooms with one person, but sometimes they wanted to be alone and not be included in other conversations. So I've also had a case where the attorney and the client spoke to one another just by telephone. So when we would caucus, you know, we kept the Zoom open, but they went, you know, into another room or muted themselves or whatever, had their private conversation by phone, and then came back onto the Zoom.
Okay. One of the things I think that all of us think of is that getting together is always the best option. I think initially when we do get together, we're going to be wearing masks. And when I think of the benefit of mediating remotely, where at least I can see the faces of the folks, while it may not be as beneficial as being there like the old days, I think it will be better than being in a conference room more than 6 feet away where everyone's wearing masks, to be able to see the inflection in someone's face. Are they smiling? Are they sad, etc. Let me touch on a couple of issues dealing with advocacy on mediation. First of all, I think it's important if you're doing a Zoom call that everyone have their video on, so that when there is a joint meeting at some point, usually in the early part, everyone will get to see each other. I think it's important for the plaintiff to see the defense, for the defense folks, if it is a situation where maybe it was a customer of a store, okay, and maybe it was a contract case or a slip and fall case, for the member of the defense team to say to the plaintiff, we are sorry this happened. You're a good customer of our store. We're going to work hard today. We're going to negotiate in good faith, and we're looking forward to resolving this. The effect of that face-to-face, where people are seeing each other on their screen versus perhaps being in a conference room and wearing masks, it's a question that we're going to see how this all plays out. We've been doing this now primarily for the past 6-7 weeks, and we're learning as we go along. One thing I think that would be helpful to counsel is in the joint session that we modify our opening as mediators to get the consent of all the parties, that if someone is upset and wanting to leave, maybe there was a backward step on an offer or a demand, or maybe the progress isn't moving along, that the lawyer reach out and have a separate conversation with the mediator, whether separately in a private breakout room or by telephone, before they, quote, walk out of the mediation.
Rob, I had a case where it was actually an arbitration that we did virtually, and one of the parties did not want to be in the same room with the other side, and doing it by Zoom made her feel a lot more comfortable, and she decided to call in to the case rather than participate by video, and everybody knew that in advance. You know, this didn't just happen the morning of. But it actually ended up being a little bit of a silver lining because she felt a lot more comfortable participating. And I think we've all had clients who've said that to us before. I don't want to go in the same room with that person. Sure. So Zoom can actually answer that problem.
So a couple other things I think that I have found in the cases I've been doing is that having a position paper from you is frankly more important in a remote mediation to get a better handle on what's going on. And maybe more importantly than that, having a telephone conversation in advance of the mediation with your mediator to have a sense of, I need to have you help me with this, or here's a sensitive issue with my client. And sometimes it's in that telephone call where the lawyer will say something to you that they're not in a position to share in writing, but they will tell it to you. Again, no differently than if we walk into our mediator lounge in a private room in our office where you share it that way. Also, exchanging information in advance of the mediation. If it's a personal injury case, that the bills are exchanged, that the total amount of the bills, that the amount payable, that information is helpful so that everyone has the facts and can negotiate and can make better decisions having information. Same thing with expert witness reports. To walk into your mediation, just like if you were here in our office and say, oh, here's my expert report, and they say we're gonna have surgery on the plaintiff and it's gonna cost $250. Yeah. At that point, what's a defense to do? They haven't analyzed that case. They've analyzed a different case, so get that information exchange in advance. In terms of process, I have used the following as my general process, where I meet on Zoom with the plaintiff and plaintiff lawyer. We meet privately. I inform the defense that I'm going to need 15, 20 minutes. Maybe it's going to be a half an hour. I tell them in advance based on that type of case. Then we have a joint session. We're not talking about opening statements with jury argument. We're talking about a plaintiff, a lawyer, and sometimes the plaintiff sharing their story. Folks, we have different stages of cases. Sometimes it's pre-suit. Sometimes it's early in suit before discovery. Maybe the case has been going on 2 years, but you haven't taken the plaintiff's deposition, or maybe it was taken 2 years ago and now they're post-surgery and they can share their story. I also think that it's important for the plaintiff to have a good understanding of the defense bullet point defenses so that they can hear it. They may not always hear it from their lawyer, and I think it's helpful hearing it. And doing it by video with everyone in one room with the mediator can be very similar to sitting in a conference room. It is possible for lawyers to share PowerPoints, to share documents, and those things can be used just like if you were in our conference room. Kim, you mentioned the agreement to mediate that you forward in advance. There's also when we reach agreement. Do you use the mediated settlement agreement and share that on your screen to confirm the terms of a settlement?
Yes. So the share screen mode, which Rob is doing right now, does allow me to put up, a settlement term sheet or the USA&M mediated settlement agreement, or even one case I had, a defendant emailed me the release. I pulled the release up on my screen, and this was actually pretty cool. Both lawyers and I worked together to complete that release, and then we had the client sign it electronically. Adobe Reader, the free version, does have a signature function. And of course, you know, you can always type in the signature. But I've found that to be really very efficient, and everybody sees it. And I love being able to do that right then and there.
I'm going to jump ahead and just touch on a couple things. If you're going to remotely try an arbitration, one of the keys, I think, is preparing your witness in advance, because you may not be sitting next to them. They may be in their own house. You may be in your house or in your office. The prep for an arbitration should be no different than a prep for a trial. But one of the things that I think is key when you are not in the same room is that to think through having your exhibits, exchanging them with the other side, and having forwarded a bench book for the arbitrator so everyone has a copy of all the exhibits, everything pre-marked. And to the extent that you may have rebuttal exhibits, to have those handy. You may email them to your opponent and to the arbitrator, but certainly you can, as Kim just mentioned, share the screen and put them up just like we're doing now. A couple other points. In a remote arbitration, you could consider whether, if there is a key issue on liability, that there's a significant defense on liability, but the lawyers tell you in your scheduling conference that most of the discovery, most of the prep for a hearing is going to be on damages, to consider bifurcating the case and trying the liability component first. If there's no liability, end of case. If there is liability, a second scheduling order goes out, giving them time to do the appropriate discovery on damages. And last, before we were remote, I'd been contacted by lawyers who said there was no issue on liability on an auto case. They had a significant difference of opinion on damages, and we teed up a 1-hour hearing on damages only. They submitted post-hearing briefs. That could be done remotely. That case, start to finish, took less than 45 days. They did happen to have a high-low agreement between them, and it did come in, the award came in actually in between the high and the low. I touched on doing both telephone and video, but I will say this. You know your clients. We, as mediators, know lawyers. When it's a lawyer that we have dealt with, what I have found is having that initial session by video, having everyone in a joint session, and then excusing the defense so that I would contact them separately by telephone, and either with a bridge line or a conference line where both defendant and client can be involved, or the lawyer will just call the client. And that conversation happens in a completely different room. I leave the Zoom running for the plaintiff's lawyer and the plaintiff. I literally close the door. I go into another room. It's just like being in a conference room. And I have found that with the defense, most of the time we're talking about dollars, and I'm getting an additional offer, and then I come back and I'm maybe raising issues or focusing on another defense. But that platform where it starts by video plaintiff only, video with everyone, and then separating the defense, they log off. We see that they are completely logged off. I can then go into a different room and contact them by telephone. Kim, you were going to just touch briefly on the types of platforms, and then some high-level issues about what to do with.
Okay, and I'm going to go really quickly because we want to make sure we give Mike plenty of time to talk when we finish. There are a number of platforms: GoToMeeting, Skype, FaceTime through Apple, WhatsApp. So if someone suggests something that you're not as familiar with, and I definitely have done this in my mediations, I schedule a time in advance of the mediation and say, okay, let's practice the technology. You know, here's the button you push for this, here's how you do it, here's how you download it, and we work our way through it so that when the mediation starts, everybody feels confident and is ready to go. Do be careful when you're on Zoom or some of the other apps, what device you're using, because it may be that some other devices in the household, if you're all on Wi-Fi, are not going to work or will not work as quickly. So I had a mediation not too long ago where the lawyer's 7-year-old son wandered into the screen, no shirt on, which was pretty funny. And, you know, he was upset because his devices weren't working because we were using so much bandwidth on Zoom that other things weren't working. So just be aware of that, you know, and that's a difference. I think the big difference between like FaceTime or Google Hangout or WhatsApp is that you don't have the ability, at least on the free version, to do any kind of a breakout room. And so that's why a lot has been going on Zoom, because it's super easy to use and has this nice free version and allows for breakout rooms. And I have used them a ton and found them to be really helpful. Just quickly, in terms of some technical issues, you do want to practice the Zoom in advance and try to practice actually the same time of the day, because usage is going to vary. So it's nice to do it same time of the day. You can Zoom on a phone, an iPad, or your computer. So make sure you know what device you're using, and it is going to show up a little different. So be ready for that. But I'll tell you, the quality of the picture, even on a phone, is really quite good. Do be concerned about lighting. If you are backlit, your face is going to be very dark and the space behind you very light. And it's just not a very easy thing to look at for a long period of time. So we, you know, and again, in the cases I've done, we've actually mentioned, you know, like, hey, it's very dark there, maybe turn off the light behind you. So for me right now, I have natural light over here and I have a lamp over here. And so it's not quite equally balanced, but I hope okay. I also have a separate camera. I'm not using my computer's built-in camera. I have a separate camera that is eye level. So that's also a little different, because sometimes if you have the phone and the phone is down here, it's shooting up. And again, for a 5-minute call, not bad, but you know, if you're on for hours and hours and hours, you might want to try to do better. The microphone, the same thing. The microphone is built into your computer. That is what I'm using, although there are some very inexpensive mics that you can buy under $100. And I know that some people who are doing a lot of Zoom are doing mics and headphones, and I think that can be really helpful. You make sure that you have your backup devices close at hand. This also has been critical for me in my virtual mediations, because sometimes if you're in a rural area, you get kicked off of your Wi-Fi. So you have to be able to call in and say, hey, I need to get back in. You have to keep that email address or that email invite close at hand, because you have to have that to be able to get back into the meeting. And, you know, we also always use passwords in a breakout, in a waiting room. And we do that because that keeps the Zoom trolls away. I have not had a troll hit me yet, but I know my kids have, for example, in their classes, and we don't want that to happen. Okay, so that's why you're going into a waiting room and you have a Zoom password. And yeah, I think just the last thing, be aware that if you're talking about really kind of private, embarrassing things, and I'll give you an example. I had a debt collection case where there were some allegations of improper debt collection practices. And it was very embarrassing for the person who owed the money, and for, you know, that client to be talking about that in her house. And again, I'll use myself as an example. I have a 20-year-old son running around. Maybe I don't want him to hear about, you know, my my debts and what's happening with me financially. So you have to be aware of that and take action to make sure, as Rob said, that you're addressing it. Okay, I'm out. I'm going to turn it over to Mike. Thank you. Thank you. I am happy to chat with anybody about using Zoom informally. Call me and we can practice on it. I call myself now the Yoda of Zoom because I've taught so many people how to use it. But I'm happy to work with you. Call me.
Thank you, Kim. Okay, Mike.
Good morning, everybody. When I started preparing for this seminar about a month ago, I must admit to a little melancholy, thinking about having lost the opportunity to mediate in person. But that's changed. I really do think now that mediating electronically through virtual conference rooms is really the next best thing to being there. And so my attitude has changed and my feelings about the process are completely different. And I hope to be able to share with you why it's easy to work on various platforms. We've been focusing on Zoom, and I'm going to focus on that today. These are some of the pictures that are coming out from the Post. If you'll go to the next one, Robbie, I'd appreciate it. You can see that everything, the subways are down, everything is slow. Ever tried driving on Highway 40 and being the only car? It's a delight coming down here on a Friday morning. People racing down here. Next, please. Schools are closed, and I think I'm going to remind everybody what's been said and what's been written. Are they really going to open in the fall? No one knows. Rob alluded that trials won't take place till 21. It probably won't be until the second quarter, and it's simply this. All of you who are involved in trials, think about how you're going to sit in a room. Excuse me for 1 second. How are you going to sit in a room with 60 people and go through voir dire without having testing? How many seniors are going to be excluded? And do you want to sit in that room, much less the other people? Not to mention the jurors who will be less than 6 feet apart. So I see that there's going to be a long delay in trials, and therefore mediation may become the only settlement vehicles that will be available. Please go next. Everything's closed. We're closed on the premises, though we're all seated here today, 4 of us in a room, respecting social distances. Next, please. And we had a shopper try to bring us food. She told us that when she came, she only had about half of what we ordered. She said all the shelves at Target were empty, and this is the pictures that substantiates that. Now, next, we're all working from home. Our children, our parents, our in-laws, the whole mishpucha is there working at home, and you never know how small your house is till you spend 2 days with your children and no place to go. So those of you that have a backyard, that's where you should be spending a lot of your time, and it's okay to sit in the backyard and smell the roses. And I just want to take a second and say to everyone, from every one of us to every one of you, we want you to be safe, be healthy, and we want you all to take care of yourself and your loved ones. And we have a long battle to go before this is all taken care of, and we hope you'll join us in doing that. Would you skip to number 9? It should be there where we talk about the different platforms. Go next. All right. I want to talk to you about the 4 different training platforms, mediation platforms that I'm aware of, and go over them with you briefly. And then I'm going to focus in on Zoom. And let me tell you, I am not an expert. I'm a technophobe. I'm not a technophile. If it wasn't for my son, I would still be, I guess I'd still be mute and wouldn't even be able to talk to you today. But the GoTo training is part of the GoTo meeting complex. suite of platforms, reasonably priced, has breakout rooms. I haven't had the opportunity to try it, but the cost is under $20 per month. So I think it's got a future too. Teams is the Microsoft product that's under Office 365. I'm aware of at least one mediator who's using it, though Microsoft is saying they're going to upgrade it. Teams does have a breakout potential. It seems complicated, but I'm sure after Microsoft has upgraded it, it'll be a fantastic product. So I'm waiting to see when that comes out. WebEx is the enterprise solution on mediations. It do have breakout rooms, but hugely expensive and in several $100s a month. We decided not to do that and fell in line with everybody using Zoom. Zoom is reasonably priced. There's a free version. There's a pro version for under $17. People are using it and it's working in mediation. And the 15 mediations I've done have all been on Zoom as at least part of the product. There has been a lot of negative publicity about Zoom. And I want to tell you, it seems to be more hype than harm in this. I've been following all the pros and cons on listserv. Don't use Zoom if you have a high government contract and you do not want the Chinese government to find out about it. Other than that, its security is sufficient for most mediations. And here are some of the security features that we practice in our mediations that Zoom allows us to use. One, we have a ID and password. Critical when you're using Zoom in any capacity that you have the ID and password. And may I suggest, please don't, I'll go to the next two, if you would. The ID and password are critical. You wouldn't share that with anyone else, so don't share it with anybody. In the seminar we did today, we skipped the waiting room because the number of people that we wanted to admit. In our Zoom mediations, we have a waiting room, which requires the mediator, who's also known as the host, to allow people in. It's a significant and important security measure. And if you all are using it, using it in any capacity, you should have that expectation. We have limited the chat function to only communicate with the host so that if somebody's going to try to Zoom bomb, they're only going to get to the host on that. And at the same time, we've limited the chat button to prevent file sharing within the program. So somebody couldn't send either a virus through the program or even send some obscene materials using the chat function. The share screen function is also limited to the host, the mediator, to prevent people from putting up or displaying obnoxious material. We'll talk about it. The recording button is on in this seminar. In our mediations, there is not going to be a recording button for the simple reason we've disabled it completely for our use as mediators and obviously not to allow any participant. But I'm going to show you those buttons in a minute. So there's, we also have the ability to lock people out of the meetings or lock of the mediations. And we use all of those, though I haven't used the lock button because of potential for drop off. If we can go to the next one, please. I want to talk about, and to some degree, it may be a little repetitious of what's been said, but the first thing that's critically important is that you have an adequate Wi-Fi. I'm using my AT&T home Wi-Fi right now, and that seems to have been more than adequate to solve the needs that I have. What I have found, though, is that often clients, and sometimes when you're working at home, your Wi-Fi may not be strong enough. If your clients are in a rural area, there's a high likelihood that they may not have the sufficient strength to use the Zoom program on a camera, on a computer, and they may need to use the phone, smartphone, and they can use the audio and the video on their smartphone, and that may work better. Or depending on the strength of their Wi-Fi, they may just have to use the audio portion. And Zoom works that way. I've had trouble with rural clients, but I want to tell you, I had one trouble with an attorney's Wi-Fi, and we had to have him by phone while the client was there by video and audio. Next, please. The second critical component is to have a computer with a camera. Many of the people, and maybe you all, if any of you are at your office today, many of you, the attorneys, are using their laptop to be seen and then using their large screen to see others. And that's how I've conducted many mediations with the camera. I am told that it's impossible to get one of these cameras these days, or they're awfully expensive. But use a camera, it's critical as part of your work. Next, please. Don't ask for whom the bell tolls, it tolls for you. You need a safe, quiet environment to move forward in the mediation. You need to tell your clients about that. To tell you the truth though, when the dog starts barking and the lawnmower starts running and the children start screaming, it's actually a lot of fun for me because it brings the humanity back to what I think is an otherwise sometimes cold medium. So keep that in mind as you go through it. Ask your clients to move themselves to an area where they can move. I've had clients that had to leave the house. These are the clients, their children were so loud, they had to go out and sit in the car with their phone and for 2 hours to conduct the mediation. So it brings a lot of interesting challenges, all of which can be overcome. And next, I need to just mention briefly attorneys and clients that should be dressed appropriately, not like the people sometimes, I guess, wearing shorts. Go ahead to the next, please. And finally, it's been my experience that the bigger cases, and I've done from the 2-party to the 7-party cases, and from the 50,000 to multi-million-dollar cases, the bigger cases take a lot more time. The smaller cases seem to go just as quick, if not quicker. And you'll need to keep that in mind. So make sure you tell your client well in advance about that. Can we go to the next slide, please, and talk about dress? I just want to read to you that one male lawyer appeared shirtless and one female attorney appeared still in bed, still under the covers, said Judge Dennis Bailey. We just don't know whether the male and female attorneys were on the same side, but that's how life is. And if we could go to the next one, I would appreciate it. We've talked about a phone call in advance. We've talked about sending materials in advance. And I think, just as Kim had mentioned, it's critical for you all to have practiced on Zoom, and it's even more critical to have a practice session with your client on Zoom. Now you all won't have to, by the end, all of you who are listening, won't have to do it because you are soon to be Zoom experts, but your clients won't. And your clients will be worried and be caught up in how to deal with the platform problems and not the problems of the mediation, unless you do a practice session, or unless they are comfortable with this newfangled technology. So Kim, myself, Rob, will all be happy to go over this with you and your clients and to prepare it. Kelly will also be willing to do that. Even when she says no, we make her do it. So the thing that Kelly and Rob and I can do is simply this. We can do our opening with your client in this practice session and take care of the initial calming, show how confidentiality works, which we can't show in this seminar to you all, but we're going to still talk about the buttons. I guess at this point, it's incumbent upon me to tell you that I'm not here to sell Zoom. It's not anything other than it's a program I'm comfortable with. I'm not an expert. I'm a technophobe, and I'm not a technophile, but I can use it, which means it's pretty simple. And I urge you all to at least get familiar with it. I'm using it now for family meetings. We get together every other week and have a good time doing it, making fun of each other for an hour until somebody starts to cry. Can we go to the next one, please? So backup numbers, let's talk about that. When you're getting ready for this seminar, you're going, and we'll show you the invitation in a minute, but you need to have the invitation with its ID, with its password, with the phone number, cell phone number of the mediator, with a backup cell phone number of our office in case there's a problem, with the email addresses for the mediator, with your email address available, with your client's email address. Take a breath and tell you that every number you can have available to reach and contact someone else that's participating in this session is good. Sometimes, we make all these numbers available to everybody that wants it. Sometimes, the plaintiff attorney wants to talk to the defense attorney and may go directly to him by phone during the course of the mediation. And I certainly don't mind, but I think it's a good idea to make sure that you have all these numbers available. Please go to the next. And I don't care whether you're using smoke signals or not, make sure you have sufficient information to share. Now, if you're going to, let's go to the next, please. So be ready. We want to make sure that those documents are sent out in advance, and we want to be able to have those documents ready to go. We send out the agreement to mediate, and we've provided that it can be executed in multiple counterparts, because sending it around the wheel to everybody is sometimes problematic. And we're having the attorneys sign on behalf and identify all the people that they're signing on behalf of. And I'm going to talk to you about signatures on settlement agreements, which I think we need to address a little bit further. But all of that should be done. I also want to tell you at this particular point, the sharing of information, we have precluded it, we have prevented it in the Zoom mediation so that malicious documents can't be shared. Now, I trust all the attorneys and people that we're dealing with, but just in case somebody tries to break in, and it could happen, we don't allow the sharing of documents. But that's not a problem. Everything can be emailed just as you would normally. And that's what how I've completed the mediations and had the signature documents sent around that way via email. Would you go to the next document, next slide, please? All right. You can join Zoom and join the Zoom platform at any time by going to your computer, or Google, or whatever you use, and typing in zoom.us. You will come across this sign-in program, which allows you to sign in from Facebook, with Google, or otherwise. And then when it's your time to use Zoom, you will be using the platform. Again, I'm not here to sell Zoom. I'm here to tell you why we're using it, because it works. But we are told that the Zoom platform and using it provides for more functionality and more security. And while we recommend it, that we do not require it. And one more thing, I've been on listservs watching all the negative publicity and responses to it. There's more hype than harm. WebEx and GoToMeeting each had their bad day. in the press. Zoom is getting it, but they're also getting their act together. Let's go to the next slide, please. This is the Zoom invitation you will receive from our office. And this one was sent to my son. All you have to do is push, give me another slide, please. All you have to do is hit the link that's the arrow is pointing to, and it will include the meeting password, and you will be brought into the beginning of the Zoom program. Next, please. At that point, I want you to give me the next screen. It's a little bit bigger. At that point, you'll have the choice to either allow to use the Zoom USA program that you've already have accepted or you haven't, and we don't require it, but if you allow it, then you will then go to the next slide, which will be our waiting room, which you got to skip here. And that's what you'll see on Kim's, Mike's, Kim's and Rob's and my waiting room. And here I say, I could be in the 7-party case where we had about 15 people, I had to keep putting the people in the room, coming back, letting people in. So there was a waiting time, which I've now figured out how to overcome. We stagger the admission into the waiting room. In other words, usually I have the plaintiffs come in first, do my opening with them in their own private room, and then 20 minutes later bring in the various defendants. And if you should work that out, whether you're using us or others, you should also make sure that you're coming in and not wasting any more time. We now start our Zoom mediations 15 minutes ahead of time, so you can get in and test the equipment. But when you come to this room, if you look at the very bottom of that slide, it says, if I have my glasses on, I can tell you it says test speaker and microphone. So if you'll give me the next slide, that's what join meeting, join with whatever it says there, I can't read it, with a computer, thank you. That's my technical advisor speaking. Thank you, Dan. That's, so you'll test your microphone to make sure it's working so that you can hear and be seen and be heard. Let's move to the next slide for a minute. Well, click this button. All right. So, thank you. That's what you do. All right. Now, you all are just, you see the USA&M logo and the Oculus where the participant is there. And if you look closely, you can see Dan's name as the participant, mine as the host. And you can see right beside my name, I have my slash mark through the microphone, and below that, you'll see I have a slash mark through the start video. And that's what that's what appears on your screen, that you have a slash mark on your video. I want to expand what's on the bottom. It corresponds roughly to everything you have now. Go ahead. And those are the same buttons. All right. And this is the button you see when you enter the room. All right. We will have muted you automatically when you come into a room or leave a room, for the simple security, so that you don't say something you don't mean to say in front of strangers. So when you come into this main meeting room, you will you will be muted, and either I can unmute you or you can unmute yourself. Same with the video. And now I want to go through the buttons that you see across the middle, and we'll start with the participant button. Look down at the very bottom of your screen where it says participants 126. That's how many of you are in the main lobby right now. Now, switch your attention to the middle of the screen where it says 2 participants. Come back. You went too fast. Where there's 2 participants there. That would be you coming in from the waiting room with the host, and then you're going to be asked to join a breakout room. And I'm going to show you what all these buttons are in just a moment, but let's look at the next slide now. And that shows the participants' view and still in the main meeting room. And so you're gradually coming in. You're no longer muted. And the next slide, please. Make it bigger. The next slide will show that. And then again, we're back to the participants, and we're going to talk about each one of these at length. So push the next, hit the next slide. It should give, all right. It shows you who's in your room by pushing the participants. And you all could do the same to see all the 127 strangers, friends, family members that are participating here today. So you know who's in the room. And this becomes of great import to you all. Yes, use your arrow, show them up there in the upper left, Robbie. This tells you who's in your room. This is your security. And when you're ultimately placed in a room, you will know who's there with you. Next, please. Go ahead. Did you hit the next slide?
Yeah, it's chat.
Chat. I'm sorry. Oh, it's blocked in mine. The chat button, as I told you before, is only operative in the example we show. You can get a hold of everyone, but now we've limited it to host only, again, for security reasons. And that's that's how it'll work. Go ahead to share screen. This has been disabled for the attendees, though the host mediator can share it. Continue. The record button, please check with the host. That record button will not be there when you are mediating with us. It's been taken off. We can't record either when we're mediating. And we want to go to the next slide, please. So the host is going to ask you to move into a breakout room. For you all right now are literally in what's called the main session, which for lack of I think a better term is, I call it the lobby or the general conference room. And then we're going to ask, the host will push a button and assign you. You will not see that, but he will assign you to a room. In this particular case, if you look move your arrow up a little to the left where it says Mr. Smith, that's the room we designated for today as the plaintiff's room, where you were supposed to go. So we're going to assign you to that room, and then you have the option back to where it says join the room, join the breakout room, which is the virtual room. You have the option to join it then, which is what we want you to do, or push later to the left, which would indicate to us that we've made a mistake and put you in the wrong room, which is another security feature, that you will not be put in a room you don't want to go into. If you should get there by mistake, you would simply announce who you are, and you can leave, and it'll show you the leave button in just a minute. But let's go to the next slide, please. So the host is inviting you to join the breakout room. You push the join breakout button, and you go into the room next. What's that say? Somebody with eyes? Oh, thank you. All right. This is what you're going to see once you enter the breakout room. If we did not create breakout rooms in this webinar, for the simple reason it would take too long to move all 127 of you into one or two rooms. So what we want to just tell you is, when you're alone, there's only one. When there's 127 of you in a room, you'll know that. The chat function is the same as I told you before. The screen share function is the same. The record function is gone. The ask for help is the way we want you to communicate with us to tell us you need the mediator. We'd prefer you not to use the chat function. And the reaction button is either a thumbs up or a clap. I haven't used it. People are applauding me all the time, but maybe that's because they want me to stop talking. Go to the next button, please. You can invite the host. That's what happens when you push that button. You invite the host to come in. Very effective. And I'll find that wherever I am, even if I'm in another room, another breakout room. Here's the important thing you need to remember, and I said it before, and I want to repeat it. Once you are assigned into a room, you and your client are in virtual seclusion only with the two of you or anyone else that you know is in the room by identifying the participants and who's with you. So you're safe in that room just as you are have the same confidentiality that you'd have in a real conference room. And that virtual conference room can extend for thousands of miles so the two of you can be together and talk and conduct business that way. Please go to the next. I can't even begin to read that, it's too small. Good, next. So it's time to leave or it's time for the joint session. And that returns us, the way we conduct the joint session is simply to bring everybody together, and the mediator will close the rooms after he's consulted with everybody saying, I'm going to close all the rooms so everyone can meet for the meet and greet or something in between for the full-blown joint session. And he will push a button that tells you to return to the main session. Then automatically you'll see that the breakout rooms will close, the 3-second delay from the minute, and you have up to 57 seconds to move from one room to the next. But I usually ask the people that move in immediately so we can start. But if there's a conversation that came up, you have that full minute. In fact, if you need to go back at the end of that period of time, you will, I can put you right back in your room and you could continue your session before the joint session. Let's move to the next slide. Well, that's it. The bibliography talks, there's a lot of stuff out today. Some of those talking about the problems with Zoom, some of those talking about what insights on virtual mediations that others have written. There's a whole litany and library of stuff going on. There's Zoom fatigue and there's Zoom learning. I wish you all safe Zooming, and again, stay safe, be healthy, take care of yourselves and your family.
Michael, thank you. This is a process, folks, and we have been learning it over the past 8 weeks. One thing I will say is if you're interested in Zoom or frankly any of the other platforms, they have free training videos on their website, and feel free to go to those. But Mike and Kim, thank you so much for sharing your experience with these platforms and your expertise. I'm going to take this off and then open up our next material. Give me just a second. Okay. Just a sec. Close mic. We're going to open up our next program. Okay, I think we're up and running. So before I get started, I do want to mention one other thing to everyone. We are currently going to plan our program that was originally going to be at Washington U in June, on June 12, as our next webinar. So that June 12 program will have 3 components. We're going to have one that's covering diversity, inclusion, cultural competency. For those who weren't able to make our program today with Dean, Mike and Kim are going to do a program on the science of mediation, the psychology and physics involved in mediation. And we're going to conclude our day with a judicial roundtable on professionalism. That'll be our ethics hour. Judges Colbert Botchway from the City Circuit Court, Judge Schroeder from the St. Louis County Circuit Court will be part of that roundtable. And one of our newest mediators, Judge Michael Jameson, will be the moderator of that program. We're looking forward to that, and we'll have a flyer out within the next few days relating to that, and welcome you to join us then. Folks, we are very fortunate to have our next speaker. Stephanie Villinski is the Deputy Director of the Illinois Supreme Court Commission on Professionalism. And some of you might think, gosh, let's see if we can just still finish at noon. But folks, we're dealing with a presentation from the Deputy Director, and part of what they do on the Commission on Professionalism is to deal with various CLE programs. I would suggest we're going to go till about 10 after 12 so that Stephanie can have the full amount of time for her presentation. And I want to make sure that she is not muted and she's ready to go. Stephanie, without further ado, we appreciate you joining us, and there we go. I've got you back to your first slide. Thanks very much.
Thank you. Thank you, Rob, and everyone for having me today. And thank you all for...
For some reason, we cannot... Okay.
Can you hear me? No. Am I good? I'm not sure. Can somebody let me know if they can hear me or not?
Stephanie, okay. You're good to go.
I'm good to go. Okay, sorry. Thank you all for joining in this new normal of online CLE, which probably, as everyone was just saying, will continue for a while. As Rob said, I am the Deputy Director of the Illinois Supreme Court Commission on Professionalism. And just to give you a brief background, prior to joining the commission about 2.5 years ago, I spent about 15 years practicing mostly in legal aid work at places like LAF, now Legal Aid Chicago, Illinois Legal Aid Online, and places like that. And so today, in terms of being healthy and well, it's really obviously taken a whole new meaning during this COVID-19. The lawyer well-being movement was definitely gaining some steam prior to COVID, and now it really is beginning to take off as people in the profession are really looking to how can we, pay more attention to this, and under this kind of unusual circumstance we're in. So today we're going to focus on, how to be practice law and be a healthy attorney, and really why those two things are needed to join together to be successful in the profession. So typically I, normally would have this be very interactive. This obviously just, makes it a little more challenging as I, can't really see your reactions and all of that, but feel free to put questions in the chat box as we go. I will ask you a few if you want to participate, with some answers in the chat box as well. So go ahead with the next slide. So in terms of the Illinois Supreme Court Commission on Professionalism, for those of you who are not familiar with us, we were started in 2005 by the Illinois Supreme Court, promulgated by Rule 799, Supreme Court Rule 799, for those of you who are rules folks out there. And our main mission is to improve civility and inclusion within the legal profession. So that is a pretty broad mission, and we do that in several ways. One is, as Rob was saying, Education CLE. We approve all of the professional responsibility credits in Illinois for Illinois attorneys, and we obviously also do a lot of education ourselves, such as things like this. We if you follow us, we have a pretty active website and blog where we write a lot about professionalism issues, and we are big in social media, on Twitter, if that is something you are interested in, to follow us. And we recently just developed, at the beginning of COVID, a video series called Reimagining Law. It's a weekly series that is going on where we talk in about 8 to 10 minute videos with attorneys and judges and others in the legal profession to talk about how they are adapting to this new normal, and then preparing for what happens after this. So that's on our YouTube channel, and worth checking out as well. So in addition to the education, we have a mentoring program. It's a year-long mentoring program that's focused on professionalism issues. I'll talk about that a little more later. And we also work with judges on professionalism issues, and also law students to try to get the conversation of civility and professionalism early on in one's legal career. Go ahead to the next slide. And you can just, yeah, that's great. And so today, this is where we're headed. We're going to aim to get these 3 learning objectives down today. And it's really focusing on, first, why, substance abuse and mental health. Why is it important to know about this, and why is it an issue in the legal profession? And then also talk about what are some of the strategies that you personally can try out in terms of building resiliency, and then also talking about the national, there was a national task force on lawyer well-being who's provided a lot of helpful recommendations as well to employers, bar associations, and things. So we'll also talk about that. Go ahead to the next slide. So I'm not sure how many of you remember this article. It is called The Lawyer at the Attic, and it appeared in the New York Times in July of 2017, so almost 3 years ago now. But this really was one of the key pieces that led to the lawyer well-being movement. It is an article that I, definitely would recommend, reading if you have not. It really gives a chilling account of the pressures and stressors of being an attorney, and when those pressures and stressors really go unchecked, and what can happen. So it tells the story of Peter, who's an IP attorney in Silicon Valley. He, has been practicing for over 20 years, typically worked over 60 hours a week for those 20 years. And the story goes as far as one morning he was found in his bathroom surrounded by drug paraphernalia. He, died of a bacterial infection that's often caused by IV drug use. No one really could predict this. Nobody saw it coming. No one, his family, the people he was working with, he really kept it pretty secret. You know, obviously it's a very grim story. And, you know, one of the things that really stood out for me about the story was, you know, in the morning when all this took place, he was, you know, in and out of consciousness, and actually his phone record showed that, you know, he was dialing into, you know, a work conference call, you know, that morning. Go ahead to the next slide. So, you know, if you know, have been watching some of this throughout the past several years, there's, you know, it has begun to, as I said, pick up some steam, the lawyer well-being movement. There's been a lot of headlines that have come forth. You know, take a look at a couple that I've posted here, and it, you know, it definitely is becoming, you know, definitely coming to light, and people are beginning to talk about it more. I'll go ahead to the next slide. So, you know, I've mentioned the New York Times story. I've, you know, showed you some other headlines. You might be saying to yourself, okay, but really, is there any data that proves that mental health and substance use are an issue in the legal profession? And so the answer to that is a confident yes, unfortunately. So in 2016, there were 2 studies that were done that came out. One was focused on attorneys and one was focused on law students, and both yielded some very stark data on substance abuse and mental health issues in the profession. Go ahead to the next slide. And you can just press it all through. So, you know, first we want to focus on the the attorney study. And this was done by the ABA and the Hazelton Betty Ford Foundation. And they looked at responses from almost 13,000 attorneys across 19 states. And, you know, what they found is 1 in 5 lawyers describe themselves as problem drinkers. And go ahead, you can hit the next. And this seems to be, you know, 27% said this problem began in law school, and you can hit the next. 44% said the problem began within the first 15 years of their practice. And so this is a bit of a shift change. In studies, there was studies that were, so this was 2016, there had not been any studies done on this topic in the profession since the mid-90s. And at that time, in the mid-90s, there was still, there was an issue at that time of drug or substance use and mental health issues, but they were more focused on, at that point, attorneys who had actually been practicing for several years. And so this is a bit of a shift change in the fact that, now we have, it seems to be starting earlier on in one's career. And, you can say to yourself, like, why is that? I don't know if there hasn't been a ton of study on maybe why that is, or we don't have a clear answer, but some of the things we can definitely conclude are, we know that since 2008, the job market in the legal profession has not been outstanding. It was starting to get better. As we know, things are not going to be great, post-COVID, during COVID, and there will be more, following. But, the market not being great and the fact that the law school debt is so high compared to the earning potential. So you have all these, students coming out of law school with high debt, difficulty paying that off in addition to all their other bills. So that is, a lot of the conclusions people are making for some of that shift change. And you can go ahead and hit the next. And this, is interesting as well. There are, if you look at this, the data on a lot of this, there, in terms of substance use, there is more found in the highly educated workforce, doctors, et cetera. But lawyers, definitely outpace those in the highly educated workforce, which is definitely an interesting piece of data. Go ahead to the next slide. So I mentioned, in addition to the substance use issue, there's also the mental health issues. And, you know, we at the Commission are not experts in this area. The Lawyers Assistance Program is really the clinical folks on this, and I will talk about them later. But, you know, they've talked about, obviously, there's typically the substance use and the mental health issues kind of go hand in hand. So lawyers in the same study reported 28% said they were suffering from depression, 19% from severe anxiety, and 11.5 had said they had suicidal thoughts during their career. So if you want to put in the chat box, I'd be interested, you know, a Y or an N for no. If you find these, if you find this data surprising, are these numbers surprising to you? Just a Y or an N if you feel so inclined. It'd be interesting to see what you guys think. Go ahead to the next slide. And the second study I mentioned was the law school study, and this is called Suffering in Silence. And this study was implemented in the spring of 2014 at 15 law schools about alcohol use, drug use, and mental health concerns. And the study came out in 2016. Similar to the lawyer study, there is, you know, not great news on the law student front. Can you go ahead into the next slide? And so as far as alcohol use, 1/4 of the law students are at risk for alcoholism. Again, you can see that the law students outpace other graduate students in terms of problem drinking. And then going to the next slide. And similar data here for law students, like attorneys, 17% are experiencing depression at the time of the survey. The anxiety also 14 to 23%, and then 6% said that they had suicidal thoughts in the last year. Go ahead to the next. So, you know, why does our profession have this problem? You know, there's several reasons. I'll go over a few of those. Go ahead and hit next. So, you know, it's alcohol in the legal profession. You know, there is a lot of overlap, and it's deeply ingrained if we're being honest about it. You know, I think back to, you know, I graduated in a while ago from law school, but I definitely remember even that first law school orientation, that first day. You know, there was a you know, big party, you know, in the evening for everybody starting law school, that a lot of alcohol was present, you know, and that continued obviously throughout law school. At most events, alcohol was pretty easily attainable, and it continues throughout your practice as well. You know, I know for me, we at the Commission attend a lot of, you know, events after work, whether it's bar association events or fundraisers or things like that. And, you know, it definitely can be at certain weeks where I have 3 to 4 events after work. There's definitely alcohol available at all of those events. Go ahead to the next point. So lawyers, the next thing, you know, reason why that we have some of this problem is lawyers do not typically seek help. And lawyers, you know, are conditioned to, as we know, really portray that we're strong and confident, and, you know, seeking help for unhealthy behavior really isn't part of that image. Go ahead to the next one. You know, wellness not being emphasized in the profession. You know, starting in law school, people often begin to kind of like drop off with the things they're interested in. And maybe it's like, you know, you used to exercise, you know, 4 or 5 times a week, and that drops off. You used to play in a band, you don't have time to do that anymore. So it's easy to, you know, lose focus of the things that are important to you. Go ahead to the next point. In Illinois, this is an interesting stat. So 80% of attorneys work in solo or small firms. And obviously this can be very isolating. You know, over the past decades, you know, you think about it, technology's really enabled us to even be more isolated and sit alone at our computers. And, you know, historically, the profession had, you know, it was definitely more active to be, more encouraged to be part of a bar association. There's a lot more events going on that people attended, and you know, it seems the trend is the numbers in bar associations and other legal associations are going down. There's just not that same kind of community and collegiality, so there is a very isolating feeling out there. And then finally, hit the next point. And then, you know, lawyers in the legal profession, you know, we are not known for being quick to change. So, and that's just a reality. It's not part of our MO. So, you know, what is part of our MO is, you know, we focus on, you know, the billable hour, and that's really the focus, long hours. If you're not putting in that kind of time, you know, there is still that kind of feeling of, well, maybe I should be doing more. And there really isn't any sort of big push to take care of yourself. That's not really part of the lexicon in the profession. Go ahead to the next slide. And so, you know, this is a professionalism ethical issue when you think about it. And the ARDC is one of our sister organizations. We like to say that, you know, we are the kinder, gentler side of the ARDC. But they, you know, a lot of their cases stem from substance abuse and mental health related issues. And it goes to just, you know, the core of some very practical rules, starting with 1.1, just simply competence. Obviously, if you are being impaired by substance use or struggling with some mental health issues, it's really going to be challenging to competently represent your clients. Next, it should be say rule 1.3, I got 1.2 in there, which is not correct, which is diligence. And it's the same kind of thing, you know, the ability to follow through on things with your clients, with, you know, court filings is going to be challenged when your focus is not, you know, readily available or easy to tap into. Go ahead to the next slide. So, you know, why should we care about this, right? There's, you know, obviously there's a lot of reasons, but you know, one of the main ones is the reputation of the legal profession. You know, as you know, the jokes are still out there, and the profession could still use a boost rather than a setback in terms of our reputation. And, you know, the clients seeing this, just the public seeing this, stories like this, you know, continue to have folks lose faith in the justice system. It's also a huge cost to insurers, law firms, regulators, and as I previously mentioned, numerous ethical violations stem from these issues. Go ahead to the next slide. You can go to the next slide. So, you know, what can each of us really do? So I just laid out all these grim facts and data, but the good news is there are things that can be done, and they don't have to be huge revolutionary things. They are, you know, some very small things. So what we're going to do first is, you know, kind of begin by focusing on yourself and what can you do. Go ahead to the next slide. So all of us, you know, have had setbacks in our lives, both personal, professional, when we think about it. And our ability to really bounce back from those setbacks is, you know, our resiliency. And no question, the legal profession is stressful. And, the question then becomes, how can we, manage it? And, it does come down to resiliency. If someone is resilient, their ability to respond to stress in a healthy and adaptive way is much stronger than those who don't have that same type of resiliency. Go ahead to the next slide. So this is an interesting data point to take a guess at, if you want to take a guess in the chat box. How many attorneys out of 10, you can go back one more, how many attorneys out of 10 rank in the 30th percentile or lower for resiliency? So think about that for a second. How many would you think, out of 10 attorneys, how many rank in the 30th percentile or lower for resiliency? Typically when I do this presentation, most people start guessing 4, 5. The reality is it's actually 9. So 9 out of 10 attorneys rank in the 30th percentile or lower for resiliency. Most attorneys are surprised by this. If you want to look into the data or research a little bit more about that, I have it on the slide. It's from Dr. Larry Richard. He's the principal at Lawyer Brain LLC. He's a psychologist and a former litigator. If you go to lawyerbrainllc.com, you will find a lot of this. And his research shows that lawyers are notoriously bad at resiliency. And why is this a problem? Well, like what I said, if you don't have a high resiliency to bounce back, rejection and other setbacks are going to hit you hard and not be able to move forward as quickly as one with resiliency might have. So the research shows that attorneys do not bounce back well from adversity. So go ahead to the next slide. You can click the next slide whenever you have a chance. And just you can click through it. There's a lot of pictures going through it. So these are, and continue to click, I think there's about 5, or yeah, about 5. So these things listed on the slide here are markers for low resiliency. So things like, if you're skeptical, which attorneys often are, I mean, we kind of are trained that way. We are look at things, to kind of question, even when clients come to us with their case, trying to think, does that make sense? Or where aren't there a lot of gaps there? Having a high sense of urgency. We all have a high sense of urgency. I mean, things got to be filed by 4:30. You just got a panic call from a client about an emergency issue. So it's things like this that we actually are trained in. We might have had some of it before, but a lot of this, we were trained in law school, and then that carries on as we practice. This slide shows, again, like I say, markers for low resiliency, and lawyers, test high in a number of these areas. Go ahead to the next slide. So is there anything to do to improve resiliency? The good news is, yes, there is. A lot of this research about improving resiliency, if you're interested, comes out of the military. This can actually obviously be applied to other professions such as law. In the current day here, with COVID-19, it really calls for even more resiliency, I think. It's a very unusual time, not a great time for logical thinkers, linear thinkers, which a lot of lawyers can be. There's a lot of stuff that's up in the air. Just listening to, the session before this, right? What's happening next? No one knows. Because of this, I think we probably all need a few more tools in our toolbox to kind of get through the day than we're maybe used to, 8 weeks ago before all this broke out. Go ahead to the next slide. And you can click through, there's 6 points. You can click through those 6. So I'm going to talk about these 6 points more in detail. And as I talk about them, you might think, these are way too soft skills for me, or it's like these things are too like woo-woo. And that's okay if, it might not work for you. I just ask as I go through them, just have an open mind about it. A lot of stuff that used to be considered alternative medicine, there's a lot more research and data behind it saying, how effective it really can be for professionals. Go ahead to the next slide. So in terms of high quality connections, this has been shown to build resiliency, and the key here is high quality. So what I'm talking about is not your, the people you talk about the weather with, or when they ask you how you're doing, you're always okay. They always say okay to you. I'm really talking about those connections with folks who really, get to know you and appreciate you for who you are, and vice versa for you. For me, I've been part of a meditation group that meets monthly for the past 5 years, and that's been a really good source of connection. No one's an attorney in that group, which is a nice break for me. And think about what it might be for you. Maybe it's a running group, a writing group, or whatever. But it's definitely important to have that, and maybe it is even going to bar association events and talking with folks about what's going on in the profession. I mean, it seems like you guys have a great group here with mediators and arbitrators to share experiences. Those connections are key. Obviously, the reality right now is we're limited in seeing each other and being around each other. And so, definitely trying things out, using Zoom. I know you guys are talking about it, using it for the mediations, but using it, if you haven't yet, to really connect with the people you're not seeing that you normally would, whether it be family, friends, etc., or FaceTime on your phone. Just it's funny, I think about, how much prior to COVID, I was doing conference calls, and not that the conference calls are bad, but it's just such a difference to see people and have a meeting that way as well. And so it's interesting that it really wasn't part of everything, and now it's become kind of the new normal. So I encourage you to also use that technology that people are now, really embracing to continue to build some connections that you have. Go ahead to the next slide. So being positive has also been linked to resiliency. For me, I think this really comes down to controlling what we can control. If our mind focuses, what our mind focuses on typically will magnify, right? So if you, we've all probably had times where we've, been, in a rut, or kind of, can't seem to get out of it, and it kind of becomes our main focus. And oftentimes when that happens, it almost, because we're constantly thinking about it, sometimes it even gets bigger and more problems develop. I'll give an example right now. I will be honest, I mean, there's a couple times in the past few weeks where I've definitely gone down a rabbit hole of, is this ever going to end? Or is it anything going to be the same anymore? Or, you name it, you can go down that. I have a mom in assisted living. And there are numerous things can definitely just take you down kind of a negative road. And I was recently talking with someone who, encouraged to try to, she encouraged me to do a gratitude journal, which I'm sure some people have heard about. It's, she said, just take a few minutes, when you get up, and write 2 to 3 things that you're grateful for, and then do the same thing when you go to bed. And it doesn't take a lot of time, but the research out there on gratitude shows that it really does shift one's thinking and kind of pulls you out at times of that kind of negative thought process we can unfortunately get stuck in. Go ahead to the next slide. So perfectionism, this is a tough one for attorneys. I think there's a lot of perfectionists out there in the profession, but research shows that being perfect at everything, checking everything off the list is really going to take a toll on your resiliency. So I think it comes down to really that it's good enough kind of thing, which I think, again, is hard in this profession. I'll give you an example. When I was at Illinois Legal Aid Online, we were moving from 5 websites to 1 website, and it was just a brutal process. It was a lot of, just a lot to get the content move from 5 websites to 1 website and how to do it. There's a lot of people involved, et cetera, et cetera. But if, we hadn't really said at moments, okay, this is good enough, we'd probably still be working on it to this day. So I know, you can relate it as well to a brief that's due. There's only a certain amount of time to get it done, and you gotta really focus on the key things and, do the best with the time remaining on the rest of it. Go ahead to the next one. So 168, you might be thinking, what is the significance of this number? Some of you might know. I did not know until I kind of looked into and read about this idea. So 168 is the number of hours in your week. And the good thing is this is something that is a great equalizer for everyone, no matter who you are. We all have 168 hours. Nobody has any more, nobody has any less. The difference is what you're doing with that 168, right? So, when people say, do 110% on this, or, it's really not, it's kind of a misnomer. We can't do 110%. Nobody has 110% to do. We all have 100%. And there's this myth that there's a trade-off between high performance at work and taking care of yourself. And I think law is one of the last fields to really recognize this because we're so entrenched in the billable hour. And so there's a good quote that I've written down from Arianna Huffington in her book Thrive. She says, when the habits that lead to resource depletion are the very habits that we are incentivized to cultivate, it makes for a tough environment for change. I'll read that one more time. So when the habits that lead to resource depletion are the very habits that we are incentivized to cultivate, it makes for a tough environment for change. So think about that in terms of, the legal profession. So this brings us to kind of that whole notion of work-life balance. And, honestly, in my opinion, I don't think, just a reality, no one, maybe there's a few people out there who have work-life balance, but I don't know any of them. But that said, I think we all know, if we're being honest with ourselves, that we could do better at finding a better balance in our lives. And so that's what we're going to talk about a little bit. So go ahead and go to the next slide. So, as I mentioned, we're attorneys, we're used to working by the clock, billing our time. In a book by the author's Henry Kramer, the book is called Values to Action, the 4 Principles of Values-Based Leadership. He talks about the importance of regularly assessing your life priorities. So he introduces an exercise in his book that I want you to try out today. It's just for yourself. You don't have to share it with anyone. There was a handout that you received for this presentation, and Rob, if you're able to pull it up on the screen, we can reference that. But on the handout, what Kramer does for this exercise is he divides his life grid into the following categories. So it's kind of those buckets of career, family and friends, spirituality, health, fun, recreation, social responsibility. And so the exercise is to, in the one column on the worksheet is to write out what your goals are. How do you want to break up the 168 hours that you have in your week? So think about that in terms of those buckets. You have 168 hours. What is your goal for the week? And then in the next column, I want you to write what's the actual amount of time you spend during the week in those same categories. So think about whether it be the past week, the past month as an average, think about how much you are spending in reality on those different things. So if you take, I'll give you, just a few minutes to work on it, to think about in the one column, or if you don't have the worksheet, just, write it down on a piece of paper or on your computer. What's your goal for your 168 hours in those categories? And then what is your actual? So go ahead and take about 2 minutes to begin to do that.
Stephanie, this worksheet is the first page of all your materials that we had on the link that we sent to everyone. So it's the very first page of your program materials.
Thank you, Rob.
Stephanie, just let me know when you want the main PowerPoint back.
Okay, great, thank you. Rob, you can go ahead and put it back. If you go to the slide that just says assign the 168 with the buckets is great. Yeah, perfect. Not many of you probably finished in that amount of time, but I recognize that I'm probably the last thing you're listening to before lunch, so I will not prolong. But I definitely encourage you to, if you find that useful, to finish filling that out. If anyone wants to write in the chat box any revelations or thoughts from that exercise, feel free to do it. I will say when I did it, you know, it definitely, it's a stark reality about how much time you quote unquote have as free time when you know, if you're working, you know, have a family, you know, it's really, it's right in front of you, like, wow, I really don't have a lot of free time. I mean, I think we all know this, but just seeing the numbers, I don't know, for me, it was kind of hit me. And the thing that probably hit me even more is in those buckets, you know, I didn't even include things like, you know, eating, grocery shopping, cleaning, chores, whatever you want to call it. So, you know, my actual versus my goal was, you know, even more out of whack than it actually looked. So, and I don't mean to, you know, do this to discourage you or, you know, but I do think it's, you know, seeing it written down is very telling. And what, you know, in the book, Henry Kramer recommends, you know, doing this exercise, you know, maybe every 4 to 6 months, and beginning to reassess it. So today, you know, if you've done the exercise and you look at it like, wow, things are really out of whack here for me. How can I get it more in line? You know, think about where you can kind of drop some things. You know, for instance, you know, with COVID going on, there's a lot of obviously negatives, but, you know, one positive is, at least for me, I've gained some time in terms of, I mean, I am working from home. I've gained time from traveling to work, to and from, you know, even getting ready for work. You know, I can get away more with not, you know, being in the suit all the time. So, you know, I was trying to think about the other day, it's like, well, what have I done with those extra 2 to, you know, 3 hours perhaps that I've gained? And I probably would say a lot of it has been working, unfortunately, but, you know, thinking about that, if you've gained any time, maybe you haven't, but even if, you know, as these, you know, 8 weeks of COVID have been going on, you know, thinking about, have you been doing something that, you know, that actually has been useful? Like you've been going outside and getting a walk in, and you never did that at the office, or whatever it might be. Thinking about, hey, I want to keep that, you know, in my life going forward, you know, when we quote unquote go back to normal life. So thinking about how can, if there's something you're doing now that has really been beneficial, that you weren't doing before, thinking about not letting that go when you go back. Go ahead to the next slide. Another thing that builds resiliency is just the notion of giving. So that, you know, research shows that volunteering results in things like lower rates of depression, higher reports of well-being. So obviously for us in this profession, there are opportunities for pro bono, and it also gives you, you know, not only is it giving, it gives you a chance to possibly do some work that you have, you know, never done before, something you've been interested in, you're passionate about. Obviously coming from a legal aid background, I know that there are, you know, a lot of opportunities out there if, you know, something like this resonates with you. For example, I'll just mention, I know the Public Interest Law Initiative, or PILI, P-I-L-I. They're based in Illinois. They're a statewide organization. They have a lot of opportunities that are online, that they have a COVID-19 legal answers task force. So you can go online where people can write questions that they have, and attorneys can respond to those. So there are opportunities, you know, even now where you don't have to, you know, represent someone in the traditional sense of going to court, etc. Go ahead to the next slide. And then finally, number 6 is finding positive outlets for stress. So it really comes down to building your resiliency through that. What is it that is, you know, helps you, that you enjoy doing? Playing music, exercise, you know, our state you know, for me, it's really been, I would say, you know, I mentioned the meditation, but yoga too. I started practicing yoga in law school and have found that, you know, it helped me throughout law school and in the practice to really kind of put things in perspective when, you know, things kind of seem to go off the rails. And I'll just mention in terms of meditation, you know, lawyers love data, so I'm gonna talk about that. You know, in terms of meditation, there are many studies out there. Harvard study on meditation that, you know, found that just after just only 8 weeks in a meditation program, there was actually a measurable change in the brain regions associated with memory, sense of self, empathy, and stress. So, you know, 8 weeks, we've done that already in this whole COVID, you know, it seems like maybe it's a long time, but you know, we know it's really not. So, you know, and also within that study, you know, in addition to, you know, enhancing the concentration and memory through meditation, a lot of data on just feeling better, both mentally and physically, with significant signs of improvement in blood pressure and hypertension, decreasing it, lower cholesterol, improved immune function, which obviously we could all use right now during this time. Go ahead to the next slide. So we talked about what we can do ourselves. Our talk is briefly about what organizations, employers can do as well. Go ahead to the next slide. So there was, I mentioned the National Task Force on Lawyer Wellbeing. These were the groups that made up that task force. They began in 2016 and with the focus on improving well-being in the legal profession, used a lot of the data from the 2016 studies I've already talked about. And they developed a report that came out in August 2017. Called The Path to Lawyer Wellbeing. It's a long one, I'll say that, but I do recommend, you know, giving it, you know, Google it and check it out. It gives a lot of great recommendations and it is worth taking a look. Go ahead to the next slide. And you can kind of just click through here. There's, I think about, yeah, one more, that's great. So the one thing the report does that, that I like is it really looks at well-being when it defines it as a holistic thing. So, which I think is nice for attorneys because we typically kind of, you know, you see here on the screen, there's all these components, we kind of end up focusing on the intellectual a lot and, you know, analysis, critical thinking, but the report advocates that it needs to be broader than that. It needs to encompass things like spirituality, emotional, physical, etc. And, you know, the thing that it also says, which I think is helpful, the report says, is that this, you know, well-being is a continuous process, right? It's going to look different, you know, year to year. Maybe you have, you know, a sick family member one year and that is taking up a lot of your time, or, you know, you have, you know, a major trial that, you know, just ends up taking a lot of time. So you are going to spend more time on that. And that, you know, is just the reality. So, you know, kind of just knowing that well-being it's just a process, it's flexible, and trying to, you know, see how well you can try to incorporate, you know, these kind of holistic things into your life, even with everything going on. Go ahead to the next slide. And so, as I mentioned, you know, practical recommendations for change in this report, they actually give 44. So as I said, it's a little lengthy, but the thing that's nice about the report is it breaks it down into recommendations for the following people, like on the slide: judges, law schools, bar associations, lawyers assistance programs. So you can kind of look at the recommendations for each of those categories, which I, you know, think is nice. Go ahead to the next slide. And you can click through. Yeah, that's great. And so as I mentioned at the beginning, the commission has a mentoring program. One of the things that the report focuses on is how mentoring can really help with lawyer well-being. I'll just put a brief plug in for the commission's mentoring program, which you can find out more about on our website. But it's a year-long program. We've been doing it since 2011. A lot of success comes out of it. It's focused on professionalism areas between the mentor and mentee. So it's not as much focused on how do I file that motion, how do I deal with the clerk's office kind of thing. It's really focused on issues like professionalism, civility, diversity and inclusion, mental health and substance use, going to an event together or with the mentor and mentee, we're talking about what's been your experience in terms of diversity and inclusion? How can it be improved in the profession? So the requirements really are for mentees 1 to 5 years out of law school, mentors 5 years and more. You can go to the next slide. The great thing is that you get free, your 6 hours of professional responsibility CLE credit are met with this program, which is great, including the two new carve-outs of mental health and substance use and diversity and inclusion. And I'll just say that at the data really shows, like even last year, 99% of those who participated said they were planning on continuing the relationship going forward, and both mentors and mentees really got something out of the program. So I definitely recommend mentoring as a good option in terms of well-being as well. Go to the next slide. And then I'll just also, like I said, put a plug in for the Lawyers Assistance Program. They also are a sister organization of ours. LAP is kind of what they're known as. I hope most of you know who they are. They provide, affordable assistance, and not just, a lot of people think of them just as substance use. They focus on mental health as well. They provide affordable, and the key is confidential, assistance, and I know they're open during this time of COVID and there to help if you or somebody who is having issues. Their website and phone number are easy to access. They're throughout the whole state, and that's both. They're in every state in the country. Go ahead to the next slide. And I'll just say that, one of the good recommendations I liked in the report for employers is to think about, do you have a policy in place for handling lawyer impairment? Is there a process in your office for, to report if somebody has an issue that you're concerned about, or even if someone wants to self-report? Is there a process of who do they go to? Do people know? It's definitely worth thinking about if you need to have one. And again, LAP is a good source to kind of create something like that. So keep that in mind. Go ahead to the next slide. So want to wrap up here since we're 10 past. But in terms of next steps, and what to do next, think about, I just encourage you to think about some of those things for resiliency for yourself that maybe you can try out. Maybe it's, looking at the 168 hours in your week and kind of reassessing. Maybe it's, trying pro bono matter, or trying something like yoga meditation, or doing some more exercise. Just give it a try. Again, maybe it works, maybe it doesn't, but I really think at this point right now with everything going on, we don't have a lot to lose in terms of trying to build up a little resiliency. So thank you. You can go to the next slide. Thanks so much for having me. My information is on this slide. I know we didn't have time for questions, but I'm happy to, if anyone wants to throw something in the chat box, I'm happy to answer. But if you have any further questions or want to reach me, my contact information is there. Our website, tocivility.org, is the Commission's website. A lot of great information on there as well. So thank you, and please stay safe and well, and thank you for all you do for the profession.
Stephanie, thank you so much. What an outstanding program, and something all of us can do. The one thing that resonated with me was your comment about doing some volunteer work, some pro bono and giving back. I'm going to have a shameless plug for a volunteer group of mediators that are probably about 15 or 20 strong, that volunteer when housing court in St. Louis City and St. Louis County is held doing pro se landlord-tenant dockets. And it's been done in the city for a number of years. Our office partners with Washington U, and we're both helping to do the mediations, but we're also mentoring law students. And a former student and now the general counsel of Equal Housing Opportunity Council, Sam Stragan, has been instrumental for the last several years since he graduated from WashU. Sam, later this year, will be moving out of town and has just done a marvelous job. And a number of our mediators participate and others in the community. And we certainly welcome others to join us in mediating these landlord-tenant cases, creating great results for both sides and a great benefit to the bench, because these are cases then the courts don't have to try. Thank you for your presentation and your offer to accept comments. Mike and Kim and I certainly, and Dean has agreed to answer questions that you may have. You can certainly reach out to us. Thank you all for attending and filling out the evaluations. I would make this other observation. We have supported Legal Aid of Eastern Missouri and Land of Lincoln Legal Services for more than a dozen years that I know of. And through the registration fees that you've provided for this program, will be going to those organizations. We support them, doing so much good in our communities. We thank everyone for attending and for being such great clients of ours, and we look forward to working with you in the future. Please stay healthy and stay safe, and know that we look forward to doing another program June 12, and hope you can join us then. Have a great weekend. Thank you, everyone.
Thank you.